Well, good morning and good afternoon and good evening to everybody. And thank you for joining this second session of the Freedom of Association Summit 2021. I'd like to go over just a few technical points to start with that will help you to listen better and to participate in this session. First of all, if you need interpretation, all the speakers will be speaking in English, but we do have interpretation, and all you need to do is click on the globe symbol at the bottom of your screen and choose either French or Spanish or English, as you wish. If you have any technical problems during this session, please select Martina Hooper in the chat and send her a direct message. And I also want to remind you that this is a public session and that this is being recorded, and the recording will be available after the session at electronicswatch.org. My name is Björn Claesson. I am Director of Electronics Watch, and I will be co-moderating today's session with Gemma Friedman, whom you also see on your screen. Gemma is responsible for business and human rights at the Unison Public Sector Union in the UK, and she is also a member of the Electronics Watch Board of Trustees. So today we have a fantastic panelists, and they will do some presentation. We will have discussion with the panelists. Meanwhile, we encourage you to put any comments or questions you have in the chat function, so we can address them in the Q&A session towards the end of today's session. And I also want to announce that these panelists have very generously agreed to stay on for an extra 30 minutes after this session for a more informal dialogue. So if you're able to do so, we very much encourage you to stay for that extra 30 minutes at the end and ask any questions that you have, and get to meet the panelists a little bit further at the very end. So yesterday, for people who were able to join us, we had a really fascinating discussion about the fundamental importance of the freedom of association and the right to collective bargaining for workers to be able to address other issues such as health and safety, forced labor, and importantly, also the threat of the climate today. So today we're asking if freedom of association is fundamental, if it is a precondition for other rights, the foundation for workers to strive to improve conditions at work, then what is it precisely? What rights do workers have under the key ILO conventions on freedom of association and collective bargaining? And what are employers' obligations? And importantly, does the reality for workers match the ILO standards? So we have again a terrific panel of experts and trade unionists to discuss freedom of association in their own countries. You see on this on the screen here, you will see the Julius Carandang, who is national coordinator with the Metal Workers Alliance of the Philippines, Bruno Periera, who is general secretary of the Electronics Industry Employees Union in the Western region of Malaysia, Heyman Zhao, who is labor researcher from Myanmar and who works with migrant workers in Thailand. And we will also have David Foust, who is a labor rights expert in Mexico. He will join us through a pre-recorded video, as we are now in the middle of the night in Mexico, and he can't be here in person. But welcome to everybody to this panel. We're so grateful to you all for joining. First of all, though, to start us off, I think there's probably no better person than Karen Curtis, who is chief of the Freedom of Association branch at the ILO International Labor Standards Department. As such, she coordinates support to the ILO supervisory bodies that monitor respect for international labor standards and the freedom of association principles and rights. So Karen, welcome. I think that I know that this is a very busy time for you, so thank you so much for joining us today. We've asked you to educate us on the freedom of association and collective bargaining in 15 minutes, and so the floor is yours.
Thank you very much, Bjorn. And can you hear me?
Very well, yeah.
Okay, perfect. Thank you very much. And thanks to Electronics Watch for inviting the ILO to give this brief primer on freedom of association. Obviously, this will just be an introduction to the very important discussion that will follow of the colleagues that you mentioned who will be talking about the challenges that they face on the ground in their countries. Just a brief outline. I'll be speaking about the freedom of association from an international perspective and why it is important to human rights due diligence down the global supply chain, the identification of freedom of association gaps and how that is done in the ILO supervisory mechanisms, and how anyone else can use them to understand what those challenges might be and what might need to be done to address them, and the substance of the right. So when we look at freedom of association from an international perspective, we know that there are many, many instruments that point precisely to what Bjorn stated at the outset, the importance of freedom of association as a fundamental human right and enabling right. And of course, this was made most clear in 1998 when the ILO adopted the Declaration on Fundamental Principles and Rights at Work, where freedom of association and collective bargaining are clearly set out. And indeed, many of you will know that the 1998 declaration is quite often cited in labor chapters in trade agreements, and therefore it becomes also a very important factor in the engagement between parties to trade agreements. The ILO supervision of freedom of association and collective bargaining covers all member states regardless of ratification, which also shows how particularly important freedom of association is within the ILO framework. It's rare that even when a treaty is not ratified, the violations of such rights can be examined at international level. And this is the case of freedom of association and collective bargaining. It has a special place in the ILO Multinational Enterprises Declaration, where we can see that it provides guidance for applying rules of the game in industrial relations. Of course, the OECD guidelines as well on employment and industrial relations, the UN Global Compact, so the engagement of all members to the Global Compact to uphold freedom of association and collective bargaining, and not to forget that it's also in the Sustainable Development Goals. And in particular, there is an indicator, 8.8.2, which counts on ILO sources to determine the state of compliance in any member state with respect to freedom of association and collective bargaining. So as I mentioned, the ILO does supervise these rights, these fundamental rights, and they do it via a regular supervisory system, which means when there is ratification of the fundamental conventions on freedom of association and collective bargaining, then the member state has an obligation to report, and social partners can engage in that process to indicate concerns that they might have. But then there is also a special system of supervision which is based on complaints, and particularly with respect to freedom of association, this is where we see that complaints can be made against any member state of the ILO, regardless of ratification. That's rather important because the two main freedom of association conventions, 87 and 98, while they are well ratified with 157 and 168 member states out of 187 having ratified, nevertheless, there are main world players who have not ratified these conventions, but may find themselves before the Committee on Freedom of Association, where there will be a determination as to whether there is a violation of these rights and how to respect them. You can also see that the special complaints mechanism can also enable a vision of violation of something that's taking place at enterprise level. So not just the member state obligation in terms of legislative framework and ensuring the respect, but also what might be happening at a specific enterprise. And we'll see that a little bit more later. So this is a picture of the Committee on Freedom of Association in past years. It is a tripartite committee, and that's rather important because it also means that its conclusions and recommendations are those that have been adopted by member states, governments represented, employer business representation, and worker trade union representation. So it is really something that all have said, this is the basic minimum right that must be respected. It meets 3 times a year, and it's been quite widely solicited since it was first created in 1951. And we now actually have over 3,400 complaints that have been brought over the years to the Committee on Freedom of Association. And you'll see in this picture that a large number of complaints concern the Latin American region. This is not necessarily because it is the greatest violator of those rights, but also because there is a very active trade union movement in the region that knows the mechanism very well and will bring the complaints forward. I thought it was useful to see also that the complaints do not concern just the public sector or just the private sector. There's really quite an even balance between the public and the private sector in the types of complaints that are brought. And when you see the types of allegations, you can see that a large number of the allegations, and this refers back to what I said, that allegations can be brought about violations that take place at enterprise level, while the complaint is brought against the government for not ensuring remedy to those violations. It may concern acts of interference or anti-union discrimination or refusal to bargain collectively that take place at an enterprise level. And in this respect, actually, enterprises may be named and may ultimately be reviewed and searched through the ILO search engine with respect to complaints. If you put in an enterprise name, you can see whether they have had issues of freedom of association. And all of these determinations of violations also are linked up with a compilation of various decisions that have been taken by the Committee on Freedom of Association to ensure that there is a level playing field in terms of what is expected by governments, what is expected from enterprises, that there isn't any kind of bias in terms of what might be expected from one country with respect to another, but there's a general rule that is followed throughout. So the basic rights that we're talking about when we talk about freedom of association are, of course, in the first instance, the very fundamental right, which is the right to organize, the right of workers and employers to come together in organizations of their own choosing to defend their respective interests at all levels. So enterprise, sectoral, regional, national, and even international levels. This right, of course, is also fully tied up with the importance of ensuring respect for basic civil liberties, which are necessary for trade union rights. And here we'll be hearing later on, for example, from the colleague from the Philippines, the ILO supervisory mechanism has been following very much the global framework for freedom of association in the country and the concerns about violence and assassination of trade unionists, which in such a climate makes obviously the exercise of freedom of association basically impossible. The right of these organizations to exercise their activities free from interference, intimidation, and discrimination is a critical right. And here again, it's something that respect has to be ensured at the enterprise level, and it's the government's responsibility to ensure that respect. The right to engage in collective bargaining, and of course, the importance of respecting workers' right to strike. So when we look at anti-union discrimination in the first place, it's very clear that anti-union discrimination is not just about what takes place at the specific moment during the work environment, but also even at the time of hiring. So we will see that there are many cases that actually have come before the Committee on Freedom of Association concerning, for example, blacklisting, which would be contrary to the principles of freedom of association. Of course, any prejudice that takes place during employment, dismissal, and all on the basis of either union membership or participation in union activities. Freely concluded union security clauses are acceptable in the ILO if it's allowed by national legislation, but I want to be also very clear here because I know we'll also speak to Mexico. Those freely concluded union security clauses must be one with actual true representatives of the worker movement at the enterprise level, and we'll talk about that more later on. So the types of anti-union discrimination, as I mentioned, blacklisting at the level of hiring and firing, the non-provision of bonuses to union members, whereas other members may actually be receiving them, compulsory retirement. Repeated renewals of short-term or fixed-term contracts is also a very important element, where legislation does allow providing almost ad infinitum short-term contracts, and that these then are used as a way of saying, oh no, this wasn't discrimination, it was just the contract was over and we didn't rehire the person. Closure and relocation of enterprises also can be seen and can be proven as anti-union discrimination when everybody else that was not related to the union may be hired in the new location. It's important to the government responsibility is to prevent and to remedy these types of problems. And through that, they need to have full investigation of the allegations by independent bodies. The labor inspectorate needs to be fully equipped to do that. There needs to be an independent judiciary. It's important to have measures that ensure the protection of union leaders, because of course the leaders, if it's very easy to fire a union leader by paying a small sum of compensation, then it affects not only the individual, but also the collective, because it will be very difficult for workers to dare again to organize. Reinstatement should be a primary remedy for anti-union dismissal. Protection against interference, similarly as I'll go back. As I mentioned, means protecting the unions at the enterprise level from interference by the employer to try to bring them under its control. So any acts that are aimed at bringing the union under the domination of the employer, like yellow unions or protection contracts, which I'm sure we'll speak to later on, and supporting the trade union by financial means with the object of placing it under the control of the employer. So there are, of course, providing time off is perfectly acceptable. Any measures that might be supportive of the union by providing facilities are acceptable. It's the aim of really actually bringing it under one's control. In collective bargaining, while on the one hand, collective bargaining is voluntary, that voluntary nature should be understood as being coupled with good faith. It's voluntary does not mean it's sort of a take it or leave it, whether I want to engage in collective bargaining, but there should be mechanisms that ensure and promote collective bargaining at the enterprise and sectoral level. Conciliation and mediation should be voluntary. And if it is mandatory to go through conciliation and mediation, the results must not be binding unless the parties agree. And similarly on binding arbitration is only acceptable under the ILO principles in the case of essential services or acute national crisis. The obligation to negotiate in good faith means a genuine and persistent efforts by both parties to reach an agreement, without an obligation to conclude, but to engage throughout that process. Support measures to ensure that all the parties have the information available to them to have meaningful collective bargaining. And that might be at the enterprise level, but it also might be information that needs to be made available by the government. The recognition of representative organizations for exclusive bargaining rights is also acceptable by the ILO. In terms of facilities, Access, as I mentioned, to premises and to management is critical. Office space, message boards, time off for union work. This should also be negotiated with the employer and the workers' representatives, while understanding the need for efficient operation of the enterprise, but also the importance of facilitating the capacity of the union. And finally, on the right to strike, there are parameters that are acceptable in the ILO, like reasonable notice, secret ballot, a reasonable quorum. The right to work of non-strikers has been recognized. Occupation of enterprise is acceptable, but it must be peaceful. Social peace clauses are acceptable. And striker replacements are not conducive to harmonious labor relations and therefore should be avoided. Peaceful boycott and secondary action is also permissible from the ILO. Now, I didn't have very much time, so I've sort of rushed through that, and I'll be really happy to answer any questions afterwards. On this last slide, there is a link to the country profiles, and I just want to emphasize that that's very important because you can go into any country where you may be engaged with enterprises and see what kind of issues are arising in the area of freedom of association, either through the regular supervisory mechanism or through the Complaints Committee on Freedom of Association. And again, you would be able to research whether any enterprise had been mentioned in that specific country. So with that, I will stop sharing my screen as quickly as I can and turn it back to you, Bjorn.
Thank you so much, Karen, for an illuminating and comprehensive discussion on the freedom of association, right to collective bargaining, and the ILO supervisory mechanisms in a very short time. I do want to let people know that we will come back to you during the session for further discussion. You will be able to respond to what you hear the trade unionists saying, and of course, for people who have questions for you, then if you can stay for the last part of the session too, the last 30 minutes too, would be really good. So we're going to go now to Heyman Zha, who is our next presenter. Heyman is a, let's see, do we see her here on screen? Good. Heyman is a labor researcher from Myanmar who works with a variety of international labor support organizations. She is currently providing support to the labor movement inside Myanmar while working with migrants and migrant support organizations in Thailand. Heyman is also a consultant to Electronics Watch and has worked with us on several investigations in Thailand. So Heyman, welcome. I'm very glad you could join.
Thank you. Thank you for having me.
Yeah. So I know that in preparation for today's session, you talked with some of the workers that we have worked with over the last year about, what message would they like to give people today. But I'm wondering if to start with, if you can provide some context to the situation of migrant workers in Thailand, specifically from Myanmar, basic things like why do migrants from Thailand go to migrant workers from Myanmar, why do they go to Thailand? What kind of work do they find there? And, are the rights basically respected there?
Thank you for the opportunity, and thank you especially for providing a space for me to amplify the voices of migrant workers from Myanmar. And it is such an honor and privilege to be here with you all. Thank you. I would like to give you a bigger picture of Myanmar migrants here in Thailand. I would like to also say that when I say Myanmar workers, it means that all the workers from Myanmar, which is not includes all the various ethnicities. And I would also like to mention that Myanmar-Thailand corridor is one of the most probably complex in the world. So the amount of population of migrants worker in Thailand is difficult to say. But as of 2019 Thailand migration report by the ILO IOM, it notes that, quote, there are no definitive statistics on the number of migrant workers in the country due to high levels of irregular migration. However, it is believed that those working in an irregular status remains in the hundreds of thousands. And from Myanmar side, the government, they put in the 5-year national plan of action for 2018-2020, and then the report came out in 2016. It stated that there are at least 3 million Myanmar workers in Thailand. And also like other organizations like EIEUWRPM, they stated in their 2018 report that there are around as high as 5 million. So there are so many like different numbers.
Wow.
Because of the phenomenon like Myanmar with the long-standing phenomenon and this irregular migration is because of the, we shared a very long border, and also with the corruption, and people like get smuggled inside all the time. And the one and only legal route to migrate to Thailand is through MOU, but due to the pandemic, it is already stopped since last year. And Thai government recently announced that they are planning to receive migrants again. Before, it is influenced that because of the conflict and displacement during the last few years, it is only because of the higher wages, which is 3 times in Thailand is higher.
Okay.
But this in February, Myanmar military staged a coup. And since then, the country's economy, social, and politics have been deteriorating. And according to the Asian Development Bank and the World Bank, it is estimated that Myanmar's GDP shrunk by 18% by September, which is the worst in the recent Myanmar's history. And Myanmar jet, which has lost more than 60% of its value as well, which means that if you own, like, for instance, like $100, suddenly you only, your value is, it's only 60. And many of because of that, many have been risking everything and paying so much to be cross illegally. And from Bangkok Post article on 25th, there are around like 140 people got arrested in Tak province. And this is not just one day thing. It has happened like almost like every day. You see it in the news every day. Yeah. And workers from Myanmar engage in like manufacturing and service industry and agriculture, also like construction, and also domestic workers.
Yeah. So, okay, thank you for that, Heyman. It's very clear from what you're saying, and also from what we're seeing, and that if you're a migrant worker coming from Myanmar to work in Thailand, you're in a very vulnerable position. And you may indeed have paid a lot of money just in order to get your job, as you mentioned. You may be in a situation of debt bondage even. To turn to today's topic of organizing, if you're a migrant worker from Myanmar in Thailand, do you have the right under the law to form unions, to organize unions, to protect your rights?
Foreign workers in Thailand have a right to join an existing union, but not have the right to form or establish their own union.
Okay. Okay. And in your experience, do you see workers that you have talked to, do they try to organize? Do they want to organize? Do they come to you with issues they want to address and they want to improve in their workplaces? Yes,
they do. I just would like to just quote what they have said.
Okay.
So they said, for us, Myanmar workers, there are many difficulties to organize, and we do not have the right to organize. Organize means by forming a union, although that they are able to join like a committee. Welfare committee, they can join that, but it is the committee itself is quite different from the union, so it doesn't protect them as much as the union, of course. So they still face so many difficulties from the employer side as well. They got like retaliation and all the others challenges.
Can you give an example of what happens if they try to make their voice heard to their employers? In your experience, give us some examples. What has happened?
For instance, like in this particular the group of workers that I talked to, they wanted to improve their working conditions inside their factory, and they try to raise their voice. But since once they raise their voice, the factory closely monitor them for them to make even like, you know, smallest mistake, and then, you know, and use it against them and make them sign that kind of like warning letter, and then, you know, for them to be dismissed. And they say that so if they want to organize, they only have one option, which is that they have to think that they might be dismissed from this work. So if they can have the what you call, if they can lose this kind of work, they would still doing that. But if they cannot afford to lose this job, they cannot do. They cannot do that. So for this particular thing, for this particular case, they say that they are one of those like lucky ones, because they got in contact with Electronics Watch. Some of them almost got dismissed, and then the Electronics Watch came in, and then it didn't happen. It stopped from happening. So yes.
Yeah, but that group of workers is a group of work in a relatively small factory, and you put that in the context of 3 million workers. You said 3 million migrants from Myanmar. So you said, I think, being in Thailand. So do you see the similar conditions in a variety of industries, or is it mainly one or two industries where this is happening?
Yes, especially with the even the Myanmar, the government, they cannot provide you know, effectively provide, you know, this kind of support. Even before the coup, there are only 5 labor attaches in Thailand, which are all men. That is another issue. But you know, for 3 million people covered by 5 people, yes. So it is definitely not enough. But also there are also, of course, like so labor migrant supporting CSOs and NGOs. If they are lucky enough to be in like contact with them, they can get support and then maybe mediate and negotiate better. But there are so many more that still those NGOs and CSO are not in reach.
Great. Thank you, Heyman. We need to move on, but again, we're going to come back to you in the discussion, and I'm going to turn it over right now to Gemma, who will be moderating from now on. So over to you, Gemma.
Thank you very much, Jon, and thank you very much, Heyman, for your enlightening contribution. Before we move on to Bruno, I just want to say, as a trade unionist, that I really warmly welcome and congratulate Electronics Watch for this laser focus on freedom of association and the rights to collective bargaining now and into the future, because too few outside the trade union movement or the labour rights movement, or even sometimes inside the labour rights movement, do this. And I'm very excited to see what we can achieve. So can I just remind everyone at this moment that there will be a short Q&A session before we go into the more informal conversation. So especially if you can only stay for an hour and you've got a question that you would like to get answered, please, you can send it to Martina Hooper in the group chat, and hopefully we can give it attention then. So enough from me. Let's move on to Bruno Periera, who is, as Bjorn has said, the General Secretary of the EIEU Electronics Workers Western Region Union in Malaysia, who I've had the pleasure to work with a few times now. And Bruno's already experienced me as quite a fierce timekeeper, so apologies in advance if I interrupt you to move us on. So Bruno, to start with, could you please give us a little bit of context about the labour laws in Malaysia? Can you tell us about the collective bargaining agreements that have been negotiated between the workers' representatives and the trade unions and the employers? Can you also just say how long on average it takes to start to organise a new factory and then to get recognition with the employer, and how long as well it roughly on average it takes to then get to conclude an agreement? And yeah.
Yeah, hi everybody. Yeah, I'll start the last question first. Now it takes to get a union representation, it can take as short as 6 months, as long as which I took 30 years. So it depends on the attitude of the employer. The richer the employer, the more difficult it is, because every single step they can take it to court for litigation, and litigation can take years. And it's from one level to the High Court to the Court of Appeal, and the process may take a long, long time. So it depends on how the employer is employer's attitude towards the trade union. The process is basically the union applies, ask for recognition from the company to be the sole bargaining agent. If the company accepts, it stops there. Then within 1 month, you are given the time to give a collective bargaining proposal. And if it can be resolved within a few months, there you have it, everything is done. The longest time will be, you send a request for representation or for recognition by the company contests that. Now that's where the problem lies. Contest in the sense that, oh, you don't have majority of members, or the members that you have includes those categories which cannot be under the labor union.
And
no, there was a interruption. Yes, that you're not a competent union. And most of the complaints or the reason why the company takes the union to court is, are you a competent union? Imagine a company taking an in-house union or an establishment union, which is made up of their own staff, to the court to ask the court to determine whether this is a competent union. It's the ridiculous thing you can ever see. Why? Because they want to delay the matter. And that particular union, I think, is an education institution. It took nearly about 10 years. Because every step they challenge and challenge and challenge, because they have the money to spend and they want to keep the union out. And these are all legal. But for the union side, it's all very frustrating. And the union being an established union, they don't have the means, they don't have the financial resources. They bleed the union. So these are the what I term as frustrating energy sapping tactic of the company. The company saps the energy of the union. Those who can withstand it, they go. Those who cannot, well, they just collapse or just leave. And more often than not, they collapse. Okay. That's why it's very important to have a union which is the industrial union. If you have a company union, they sap you anytime. You can't stand the onslaught by the management.
So thank you, Bruno. Can you tell us a little bit about why the situation is like that? I mean, you know, what are the reasons? what are the tactics that the employer uses? How helpful is the Department of Labour? You mentioned you don't have very many resources. It can take 10 years. So what, you know, can you expand a little more?
Yeah, but these are normal legal processes. If you go to the court, then you have to wait for the court to fix a date and according to the court schedule, and you can expedite the court. So those are normal legal processes. So if you know how the process system operates, you can sap the union, you can sap the energy of the union financially, morally. So, and there are some lawyers who participate in it. Yeah. And why the company is doing this, that is a different question altogether, the economic aspect of it. Now, looking at the electronic industry, there are all electronic companies in Malaysia are foreign companies. There are a few which are local manufacturers, but then they depend on the foreign customers. Basically, the electronic companies in Malaysia are fabricating companies. They fabricate products. They do not, there are no R&D here. They just gather the material and set, according to specification, they come up with a unit or come up with a device according to specification of the foreigners. So which means we wait for foreign orders to come in, right? And the money and when, mind you, when the company, even if the foreign company here, which is manufacturing its own unit, so its own electronic product, it is upon completion, they package it and dispatch it to the customer. And the bill is paid to the headquarters. There's no cash register in Malaysia. There's no money in Malaysia. So when they send the money to the overseas companies and they get the money. So what comes down to Malaysia is the amount that's required to run the factory. And the person who decides the labor costs and the management costs is the local management. And when the money comes in, they distribute among themselves. My discussion, my analysis of my own company, the American company with about 250,000 2,500 workers, when money comes in, the 5 million ringgit comes to Malaysia, 85% goes to 15% of the population. And 15% of the money that comes from the headquarters for distribution as wages goes to 85% of the population.
Thank you, Bruno.
So it's the top heavy, and that is decided locally. You don't blame the foreigners for this. That's divided locally. Yeah. Now, if you want to form a union, and these people who are the 15% is threatened, and they will stop you.
And of course, a trade union gets its independence from the membership subscription fees that workers are prepared to pay that trade union. And so with those kinds of wages, there's not a lot of money that you can ask for them to pay, which of course then leads to even less resources for the trade union. Yes. So what is it like? What is it like to be a trade unionist in Malaysia? Is it safe to speak up? Is it safe to freely associate? What you know, I mean, you've been in it for a long time. You've been doing all of this for a very long time.
Well, it is safe. Bodily, you're safe. But financially, you're not. You can be sacked anytime. And there is no way you can go unless you look for another job. Physically, there's no violence here. The police, of course, sometimes come and disturb you, yes, and threatened you, yes. I have ended all that. But physically, no, they don't abuse you or anything like that. But job-wise, economic-wise, yes, they can harm you. They can sack you for no reason or rhyme. But why? Because they don't care. Because the court process may take some time, and then you're out of the scene. So the union is without a leader, and that is a very good tactic of sacking the leader immediately, because the herd instinct sets in. All the workers now shrink and go back to work obediently. I don't want to be the next person. So you control the whole herd by just getting rid of the leader. The herd is completely cowed down. It's a very
Thank you,
simplest
Bruno.
sector. Yeah.
Just for the interest of time, we have to move on. But you know, when so many people often say, "But why are there not very many trade unions?" or "Why are the trade unions weak?" You know, in the manufacturing countries. You know, you've just given us some exact, you know, some very important reasons as to why that is. So thank you very much. Let's move ourselves on now. And just a reminder, anyone with questions, please do ask them. We're going to ask similar questions of Julius Carandang, who's the National Coordinator of the Metal Workers Alliance of the Philippines. Thank you very much for being here, Julius. Can you just to start with give us a little bit of legal context about the labour law in the Philippines? Do the labour laws protect workers' rights to organise and collectively bargain? Can it enable good industrial relations?
Okay. In a paper, there is some guarantee of workers' right to organize unions. The Philippines is a signatory of the ILO Convention 87 and 98. That is the freedom of association and right to collective bargaining. Even the 1987 Philippine Constitution, being a result of the anti-dictatorship movement in 1986, has provision that guarantee the right to self-organization of the workers, collective bargaining, and even the right to strike. So the Philippine Constitution really sounds good in paper. However, when we go to the labor code, which is basically the law that is used to regulate labor relations, including the right to organize unions, it becomes very tedious for workers to form unions. In essence, the labor code allows the formation of unions. However, it has a catch, plenty of catch, in fact, because of it is a very tedious process. One, we have a one enterprise, one union policy, which means there can only be one union per company, so we don't have industry level unions. In practical terms, if a group of workers want to form a union, they have first register a union before the Department of Labor. The union has to have 20% of the total rank and file employees for it to become a registered union. The company in paper must not be must not be involved in this process. But the catch here is you need to submit the list of workers who signed to join the union to prove that you have 20% of the total rank and file of the workforce. That is already impediment because once the company learns who will part of the union, you can immediately expect the retaliation from the company. In economic zones where almost electronics are located, there is a de facto no union, no strike policy. And recently, the police and the Philippine Economic Zone Authority has signed a program that called Alliance for Industrial Peace Program that aims to promote quote-unquote industrial peace, which is another word for intervening and preventing union activities in the economic zones. By law, the police should have no business with union affairs, so they call it promoting industrial peace. So my point is, it's not only the law, but also we have to look into the current policy of the government, which can impact in the exercise of these supposedly lawful and constitutionally guaranteed rights of the workers.
Yeah. Thank you. And then just very briefly, roughly, well, in your sector, in the electronics industry, how long does it take to get a union recognized by the employer? And roughly, how long does it take to organize a collective bargaining agreement?
Basically, the electronic industry in terms of employment is the largest manufacturing sector in the country. It counts for about 25 to 30% of manufacturing. That is around 300,000 of over 1.2 million workers employed in manufacturing. Overall, less than 10% of the workers in the sector is organized in unions. Much smaller has collective bargaining agreements. I don't have exact figures, but just to give you an idea how small it, in the entire Philippines across all economic sectors, the agriculture, industry, and services, there are about 19 to 20 million workers in the formal sector. But of these 19 to 20 million who are in informal sector, only 184,000 have collective bargaining agreements. So we can imagine how little it as well in the electronic sector. It is very hard to form union and much more have to CBA. Even if you register a union, you don't have a collective bargaining right. You still don't have a bargaining rights. You have to win on certification election. This means there will be a vote among all the rank and file employees if they want a union or not. So you vote either yes or no to union. Again, in paper, management must not involve in this process. However, companies generally dislike unions, so they get involved in many ways. They can either dissuade workers to vote yes by harassing them, holding anti-union seminars, and some go as brazen as declaring the day of election as a holiday or other ways to prevent workers from coming back to cast their vote. Sometimes the management also try to form their own union or a management control union to fight the independent union during the election. In case the workers win in the election, you become the sole and exclusive bargaining agent. We call that SEBA. But then it can still a lot and a long process before you're able to get a CBA signed. Sometimes the management refuses to negotiate for many reasons. Some question the result of the elections and etc. And even for workers who already have established unions, the recognition process can take up to 4 months or even a year. Again, it's hard and it's very tedious process here.
Okay, thank you so much. Can you tell us what is it like being a trade unionist in the Philippines? What's it like for representatives who, of course, we have to remember are doing this all pretty much exclusively on a voluntary basis as part of being an employee. It's their right. Is it safe to speak up?
It is a very challenging to become a trade unionist in the Philippines. First of all, there is already a climate of fear and hostility to unions. Most workers get the idea that if they join the unions, they might be sacked, even if it's their right. So from that alone, we can see how stigmatized unionism has been, and this has a lot to do with the government policy and also the culture being promoted by the companies where they don't like unions. To be honest, simply speaking up, not just being a unionist, can be a threat to workers. We witness many workers who are afraid to talk about what is going on inside their companies, or some get harassed or intimidated by their bosses, even simply filing complaint. As you might know, our one leader, Dandy Miguel, Union of in Fuji Electric, was assassinated last March. That it itself testify how dangerous it for trade unions, especially now with the policy of the government where the military and the police have de facto more powers in civilian affairs. Then there are many instances of harassment and intimidation by unionists perpetrated by state forces. Just like what happened now in the Philippines, there has been long-standing insurgency, and the government has always linked the trade unions to armed groups to justify their attacks on unionists. This is utterly wrong and malicious because trade unionists are not armed and definitely not terrorists. So like now, now because of this policy, there's a wide spread of terrorist tagging arrests and arrest of unionist activists and home visit to union officers and even their members by the state members to dissuade or to disaffiliate them from the participating in the union activities. So
Thank you. Yeah. Thank you, Julius, for painting that really quite horrifying and chilling picture. And we send our solidarity to your union and others in the Philippines who experience something no trade unionist should have to experience anywhere. Thank you so much. For interest of time, let's move on now because we have a video by David Foust, who's going to explain how Mexico's institutional frame for industrial relationships has had significant changes in the last 3 years. particularly for labour. David has also written an accompanying article that you can access by emailing to him, and I'll put that in the chat in a moment.
Hi, I'm David Foust, and I'm grateful for the opportunity to share this presentation with you and hope that we will soon be able to do so in person. Mexico's economically active population is 55.4 million. Of this population, 36.4 million are wage workers, but only about 23 million are defined as being in formal employment, and only about 4.4 million workers are unionized, with about half of these in the private sector. 80% of these collective contracts are employer protection contracts, signed without the consent or even the knowledge of the workers. The electronic industry is characterized by high levels of precarious, subcontracted, and non-unionized employment, or employment under employer protection contracts. The Mexican industrial relations system is the result of a long and complex interaction between the winning and losing factions at the end of the 1910 revolution. In the long post-revolutionary period, this interaction produced an officially rigid but actually lax system. Ben-Susan has identified these main problems. Governmental discretion and opacity at the union's registration over the declaration of the legality of strikes at the moment of renewal of collective agreements and regarding union finances. Unrepresentative unions have excessive power, and there are legal, administrative, and political difficulties in forming new unions or in disputing collective agreement ownership. Labor inspections lack strong institutions, regulations, and budgets. Besides, the state has enabled mechanisms for self-assessment and partially privatized the inspection function. Access to labor justice is difficult, slow, and ineffective. But there are forces driving change. After assuming office during September 2018, the new majority at the Mexican Senate ratified the ILO Convention 98 regarding unions and collective bargaining rights. At the end of that year, the National Commission for Minimum Wages announced an increase to the minimum wage equivalent to 16.2% and fixed a minimum wage of 177 pesos for the northern border. Within a few months, Congress also approved a labor reform, which among other modifications includes new obligations for the employer, such as giving each employee a copy of the collective agreement, establishing protocols against discrimination, gender violence, forced and child labor, transparency regarding the consultation processes about union issues, collective agreements checking, and strike rules. This new law transformed the legal proceedings, turning functions to the judiciary branch. It includes anti-corruption provisions against the unjustified delay in the proceedings against corrupt actions taken by labor inspectors, establishes guarantees, mechanisms, and procedures to facilitate the association of workers in collective bargaining, the universal vote, free, direct, and secret by the employees, financial accountability of unions, provisions against union busting, the employee's right of not paying unions fees, among others. The current government and its majority in Congress have also passed a major agency work reform. This reform will involve direct contracts and wage increases of 15 to 30% for hundreds of thousands of workers and other important improvements in benefits. Taken together, these reforms and policies are the biggest progressive shift since 1931. But it was a top-down political process, even more than in the 30s. So, how much will it contribute to the making of new collective labor agents able to fight for their interests and bargain collectively? Can this new institutional frame effectively promote freedom of association and defeat persistent employer protection agreements? Overall, will these changes transform the Mexican industrial relations system? And in that case, how? Up to what point? In the article that accompanies this video, we look at cases of maquila workers in 3 cities who tried to organize autonomously and democratically. Based upon this analysis, we may conclude that the labor policy turn of the current government constitute an institutional frame that could stimulate workers' organization to seek greater access to core labor rights. This incentive can have more impact if there are local and regional pro-union precedents, if there are state and local governments that at least do not repress or actively prevent the creation of independent unions, and if these types of organizations build transnational alliances. Thank you.
So thanks to David for that summary of how the landscape is changing or possibly changing in Mexico. And my understanding is that through the Canada, US and Mexico trade agreement, that's aiding this as well, and giving more workers the chance to form and join trade unions that are independent and democratic, that are of their choice. And my understanding is that the General Motors Mexico plant, that is actually happening in practice. And other workers in Nissan, for example, are watching and realizing that they can do the same thing. So it's good to hear that there are some places where things are improved, have a chance for improvement. Karen, we've all heard a lot just now from our panelists, including from yourself, but we'd really like to give you a chance to respond yourself to anything that you've heard from our trade union and labour rights panelists today.
Thanks very much, Gemma, and thanks to all the panelists, of course, for sharing the many challenges that they encounter on the ground, and which shows that, of course, the ILO also continues to have a lot of work ahead of it, unfortunately. I wanted to pick up, actually, I wanted to give, because you sort of finished on a positive note with Mexico and some of the movement that we can see there. I wanted to actually build on that positive note, to talk about actually really the importance of so many mechanisms coming together to be promoting freedom of association in order to really make some impact on these very difficult challenges that workers do face around the world. And so just to highlight the case of Mexico, which really is sort of started in the ILO, it's rather interesting because Mexico ratified the Freedom of Association Convention practically right after its adoption in 1950. But then the issue of protection contracts, which, was really very much a factual issue, a factual problem on the ground, that didn't come to the ILO's attention actually until 2009. And it did via a complaint, so using that complaints mechanism to talk about, one thing is to say you have collective bargaining and collective bargaining is promoted, but is that really collective bargaining? Are they really representative of the workers? And that complaint was brought by Industrial. It was brought by an international workers' organization, a global union federation, to really put the story sort of straight before the ILO, something that wasn't happening from the Mexican unions at the time because they were benefiting from the system. And so first through that complaints-based mechanism, having that come up, then became part of the regular supervision because there was the Freedom of Association Convention that had been ratified. And then that was brought up to even higher level review by being brought before the International Labour Conference. So an international forum where all member states of the ILO in a tripartite manner were hearing about this problem, many of whom didn't know about it at all. And then having the conclusions of that committee being followed up by the committee of experts in the regular supervision, bringing a lot of attention to that. And then, as was mentioned in the video, the USMCA actually focusing on that in its labor chapter and in the annex to have very specific points as mentioned by the ILO. What were the expectations? What should be done by the Mexican government, including the ratification of the other very important convention, Convention 98 on collective bargaining. And so that happened. The labor law reform process happened. There was the ILO that was raising that and bringing it up at international level. But then there was also, of course, the trade pressure coming in, which one can't consider to be negligible. And then adding to that, through worker push, worker center push, the very important rapid response mechanism, factory specific. So bringing things down to the enterprise level to say, this is not just about the government having a legislative framework, but this is also about enterprises recognizing that they have an obligation and that they may be punished even if they're not punished at national level. And then just one step further, and this was really a precedent for the ILO, was that in the remediation process for a complaint that was brought about a protection contract, the ILO was invited by both parties, so by the US and by the Mexican government, and also accepted by the union, welcomed by the union, to be observers in the vote about the contract. And so the ILO was quite present on the ground. We know the results of that, which was that the workers said, no, this isn't representative of us. We want to have a chance to actually form our own organization. But for me, the ILO presence there as an independent, neutral arbiter, we didn't go in with a specific view of what should be the result, but we ensured that the principles that I was talking about in my first presentation that come out of the Committee on Freedom of Association, of the Committee of Experts, that all that was fully respected on the ground so that the workers could feel that they were in a secure environment to actually voice their real choice. That was just something I wanted to share, but the importance of all of those parties coming together and really, using the ILO as the clear, independent voice on these questions, but also using the various leverage that they have to bring that forward. Thanks.
Thank you very much, Karen. So, I mean, that's a really good example of how the ILO different mechanisms culminating together at the same time with opportunities, unusual opportunities in trade agreements can actually be used. It's, a bit of an aligning of the stars, as you can say. I wonder now for, just before we go to the Q&A, Heyman, Julius, Bruno, what are your thoughts on what Karen has said? How might you be able to, has this given you ideas? How are you already engaging with the ILO? What are your thoughts?
Well, in Malaysia, there's a major activity by the government to reform the labor laws, and ILO plays a major role. In fact, the middle of the month, there's this amendment to the Employment Act is going to take place, where they're going to introduce all ILO convention standards, which we have been asking for, I don't know how many years. And on Monday, we had a meeting with the minister. So things are looking up, but what actually turn up with the amendment, we have yet to see, but so far it's been positive.
Okay, thank you, Bruno. Julius, you also wanted to say something.
In response to Karen, here in the Philippines, especially in MWAP, we conduct a program about to give an education to our affiliates about the importance of the ILO convention and now to how we can participate to that mechanism. So it is not only for the workers alone, and we teach how we deal with the other stakeholders, just like how to negotiate a proper negotiation for that.
Okay, thank you, Julius. So trade unions can really contribute, as Julius is saying, you know, really a big effort to make sure that industrial relations is done in a mature way rather than something that is full of conflict and tensions. Heyman, would you like to have the last word before we go to Q&A?
Yeah, for Thailand, it hasn't been ratified ILO conventions on, you know, freedom of association, which is number 87, or the right to organize and collective bargaining, which is number 98. So as far as I know, the migrant organizations has been advocating for this for so many years, and we are continue doing so.
A lot of work to be done. Thank you everybody so much for your contributions today. It's really, really appreciated. And I think I'm going to turn over to Martina Hooper now, who's in charge of questions.
Yeah, sure. Okay, so we have a few that people have put in the chat and sent to me. We'll start with one for Karen. It's quite a long one, so bear with me. How are states and employers ensuring that the right to collective bargaining, a fundamental human right, is guaranteed for workers in non-standard forms of employment, the workers that are involved in every supply chain and making up over 60% of the global workforce? And of course, this relates to the majority of electronics contract workers trapped in a cycle of serial contracts, denied the rights to stable and permanent jobs, as well as informal workers and misclassified workers.
Indeed, a long question, but so I will tackle the question about non-standard forms of employment. For the ILO, freedom of association is for all workers, regardless of the form of employment. And regardless of the contractual status. So even the question of disguised employment, et cetera, while it's important at certain national levels, every single worker who is a worker has that right to form and join an organization of their own choosing. And that's the part that many countries have difficulty tackling, and engage in collective bargaining, including collective bargaining over wages. And you know, we have the European Union is looking now about competition authority rules concerning platform workers, and that's a big question that they're trying to tackle. But for the ILO, it's for all workers. There's no question. This democracy is for all workers. Many are not engaged in contracts We have, of course, the domestic workers that are often without any means to really be under the legislation, under the labor codes, to be considered as employees and be able to organize. So for all of these workers, that's the view of the ILO. And whenever the ILO sees that the legislation either doesn't provide the framework necessary for such workers to organize and to bargain collectively, they obviously raise those issues. You mentioned contract workers. There was a case concerning Korea where this question was raised, where again, the ILO said, no, they must be able to organize. And for collective bargaining, it may be that, for example, if you have self-employed or workers that are more in a different situation from those that can easily fall into the typical collective bargaining framework that has been established for workplaces, then you find new ways, new mechanisms, but that promote their collective voice, that enable them to engage together and then to show themselves as representative and to engage with the employer or employers. And that's where industry level bargaining becomes really important. And I know that many of the workers today, particularly Bruno, who was talking about the electronic sector, industry level bargaining is really a key to being able to get beyond and promote collective bargaining for all once you have a mechanism that is really promoting that. And unfortunately, trying to bring everything down to workplace level tends to ignore the non-standard worker. So perhaps a long question. Employers are sometimes, because the question was to governments and employers tend to like that loophole of non-standard, to say, no, I don't have to bargain with those workers. But certainly from an ILO perspective, both in terms of the regular supervision, but in terms of complaints where employers say, no, I don't have to bargain with those because they're non-standard, the ILO says, no, actually, they're working there side by side. You need to engage with the union that will represent them.
Okay, thank you for that. So now we have a question from Sonia about the role of buyers in freedom of association and collective bargaining in electronics and other sectors. In global supply chains, it looks in many cases like international buyers should be a bargaining party rather than a facilitator between employers and workers' organizations. There was discussion about cross-border social dialogue, even collective bargaining agreements, but limited within EU countries. What is the perspective for ILO and global unions to further promote the model in global supply chains?
Sorry, I don't know if that comes to me.
Well, I mean, if anybody wants to comment on it too, anybody who wants to take that question.
So, well, I'll just quickly say that I'm very much in favor of cross-border social dialogue, and I think that the ILO does need actually more mechanisms to be able to be promoting and facilitating that. It's been difficult to really get that as a real issue on the agenda, but it will certainly be something that will be reflected upon when they're looking at the global supply chain question. I think that the global union federations and the international workers' organizations are also very keen on this, and certainly we can see even in the international framework agreements, that a lot of progress can be made through such mechanisms. So that's just from my side.
Okay, I'll carry on. We've got another question that somebody kindly translated from the French. So I'll just go ahead and ask it in this channel. Hope it's been translated correctly. From Joseph. What is the attitude of the political authorities towards violations of freedom of association? Are there any conflicts of interest between these authorities and business leaders in the Philippines?
So this is a question for Julius, it sounds like.
Julius, do you want it to be repeated? Yeah, and you might want to unmute yourself.
Yeah, please.
Okay, I'll read that again then. What is the attitude of the political authorities towards violations of freedom of association? Are there any conflicts of interest between these authorities and business leaders in the Philippines?
The attitude of the politician, especially the financial freedom of association, in the problem of the workers, when we make a dialogue to them, during the dialogue, they promise that they help us. Then they say you can see just like the politician is side from the workers, but the reality after that dialogue of the workers, they say always go to the process, to the court, and then yeah, like that. I mean, the politician have they cannot stand by the workers with that kind of problem because of the personal interest. Sometimes because they have a connection, the companies have connection to the politician. Just to say they accommodate your problems. So in dialogue, they are listening, but in reality, there's no happening. That's why in our problem, we always gather a unity within the workers, just to show them the force of the workers, just like that. I hope I answered the question.
Thank you, Julius. We have another question for Karen from Martina. You mentioned that the complaints mechanism works regardless of state ratification of the ILO convention. However, what powers does the ILO have in practice over non-ratifying countries?
That's an important question, and I would say that in the first instance, it's a question of giving really putting international light on a problem, which is already very important because, as I mentioned, for example, in the Mexican case, the importance of many different players then acting on that and pushing and promoting the change. And that's something that I think, in particularly when you're looking at the supply chain, buyers and their responsibility, the push of consumers that have an expectation, a higher and higher expectation that basic worker rights are being respected. The push also needs to come from the business community. So when the international light is shown that there's a real problem somewhere, to sort of say, well, that's not our problem because that's not us directly, that's over there. But I might be actually buying from over there. I might have some responsibility. So I need to be bringing that message as well. As business, I need to bring it to my partners in business. I need to bring it across the board to the chambers of commerce or the business organizations in the other countries. and also then also to the governments, that my expectation, if I am going to work or if I'm going to buy from here, I need to be able to go back to my community and say that it's in line with universally accepted fundamental rights. Then to do that, it's very important that the problem be known. When I mentioned, for example, about Mexico, the question wasn't, there wasn't universal awareness about the problem. Now it's become something that quite a lot of people talk about, but it takes first really the light to be shown on the problem. Beyond that, I mean, it's true, it's not a mechanism where we can go to the International Court of Justice for enforcement, but I must admit that trade agreements and trade arrangements are also a very important part of the leverage that can be brought to bear to make this change.
Okay, thank you. And just one for Heyman, and then I think that's all we have so far. Dara has asked if you could comment more on migrant workers in the Thai electronics industry specifically.
I'll just give examples of the cases we have received. The situations inside the fight, the working conditions are not, of course, like unfavorable. We have some reports that they have this kind of like bruises, like rash, give them itchy because of these like small particles coming out, you know, when they're producing all these things, because of there's no like proper cooling system, and having to stand up for long hours. They have some like, you know, leg injuries and all these. And even in like some electronic factories, even though they provide like meals, sometimes it is like only like a very small amount of, you know, like it's not nutritious. Yes, it's not they provide, but it's, you know, it is not enough. There are always like rooms to improve, and there's like some like discrimination between against foreign workers, that they have to carry more workload than like Thai workers and all these like so.
Okay, Gemma, do we have time for one more question? Oh, we can't hear you.
I think we have time for one question, one brief question. Yes.
Okay, great. So we'll take this one and then I'll pass back over to you. So from Alistair, big retail buyers in Europe are most sensitive to living wage deficits, and the new German government is going to push hard on this front. Can this strategy be used in the consumer electronics sector, ensuring that trade unions are involved in verification of actual wage data, for example?
Perhaps a question then for Bruno or for Julius, if you see trade unions taking an active role in pushing for living wages for the workers, and if so, what that role might be.
Yeah, in the electronic sector, the wage negotiation in Malaysia is very static. Actually, they start with the minimum wage, and the minimum wage is for all direct labor. That is from the cleaner right up to the operators, when it should not be. Because within that category, the different categories of levels of education and skill. So at least my union, we are looking into that to change the whole structure of the wage for the direct labor. Whereas for the indirect labor, of course, we had it there since the trade union. I think we have the starting wage for a level certificate level technicians right up to managers, and depends on the qualifications. But when it comes to labor as a whole, the direct labor, it is they automatically say, yeah, this is for all. The minimum wage is for all. That is a very wrong way of doing things. So
Yes.
at least my union is looking into it, and we may have to promote this. Of course, we'll be taken to court, and I'm prepared.
Okay, thank you so much, Bruno. This is a really, of course, crucial topic for all workers everywhere to actually get paid more, because most workers in this industry and other labor-intensive industries, they have to subsist on what does amount to, in many cases, to poverty wages. So it is very good to cast attention to the question of living wage. And with this, oh, sorry about that. I'm going to go to this slide here. With that, we come to an end of this session, and I just want to thank so much all the panelists for illuminating, thoughtful discussions today. This presentation is absolutely worth listening to again for me and for everybody at the Electronics Watch, and for all of you. It will be available at the Electronics Watch website. So thank you to Karen, Heyman, Bruno, Julius, and David, who joined us via video today. And please do join us again tomorrow, when the topic will be how we can verify that there actually is freedom of association, that the right to collective bargaining is respected in public buyer supply chains in the process of public procurement.